Shariat court was previously dealing in narcotics cases. Then subsequently, when CNS was enacted, the jurisdiction of Shariat court was taken away, and now it is with High Court. So it means Shariat court jurisdiction can also be curtailed by Act of Parliament.
So with respect to Sharia court, now it says clause 3 of 203DD says such other jurisdiction as may be prescribed by law. Now it is saying that there is a jurisdiction which has to be conferred. With the Sharia court, the chapter provides what matters are to go to Sharia court, what matters can the Sharia court see. So this is all what the Constitution is providing. So there is here,
initially all the narcotics cases that will go to the Shariat court, but after promulgation of CNS Act, now the Shariat court can't hear those cases, and those cases are lie to the high courts. So it means the jurisdiction of Shariat court has been taken away, and which can be done.
My lord, what we have to see then is we have to examine this chapter and see whether what is provided.
This cannot be done in the case of Supreme Court.
No, it cannot. It cannot be done in the case of Supreme Court, because if you look at 185, my lord, look at 185. Now 185, unless we read enlargement part independent of the preceding part, then does not permit any appeal coming to the High Court from either the Competition Tribunal or the election tribunals or all the other instances where appeal has been provided to the Supreme Court, because 185 there is no express authorization.
If you read it the way you're saying, then all those other laws.
ये 185 में सुप्रीम कोर्ट के ऑर्डर का जिक्र है,
सुप्रीम कोर्ट के ऑर्डर का सर उसमें
देखिए बात ये ना, अगर आप कह रहे हैं कि जी इनलाज कर रहे हैं आप जुरिस्डिक्शन को, तो एपलेट जुरिस्डिक्शन 185 में दी हुई है, ठीक, उसको इनलाज कर रहे हैं आप, तो अब आप सोचें आप कॉन्स्टिट्यूशन के एक प्रोविजन को वहां पे कर रहे हैं, ये थोड़ा सा उसमें या तो आप सिर्फ ये बता दें कि ये जुरिस्डिक्शन और पार कौन से हैं जो नहीं हो सकते 55 के नीचे.
When it says enlargement of jurisdiction,
रिवर्स लेना, आप तो एक्सेप्शंस पे जा रहे हैं, एक्सेप्ट सुप्रीम कोर्ट, व्हेन एनलार्जमेंट है हम उसको रिवर्स में लेते हैं. आप स्टार्ट करें जहां से वो स्टार्ट कर रहे हैं कि आप पावर नहीं कर सकते सुप्रीम को, वो कौन कौन सी जुरिस्डिक्शंस हैं जो नहीं कर सकते,
जो एनलार्ज नहीं कर सकते.
नहीं.
So I haven't got it.
देखिए आप 55 को प्लीज जरा पढ़ लीजिए.
Jurisdiction and powers of all courts. There's a comma then, except the Supreme Court.
So you can't create jurisdiction or create any new powers of the Supreme Court. Fine.
Reduce नहीं कर.
So अब जब आप enhance नहीं कर सकते, reduce
enhance कर सकते हैं,
वो आप कैसे कर सकते हैं?
ये सर ये
वो आप देखिए ना, वो तो आप कौन सी एक jurisdiction होगी जिसको आप enlarge कर रहे हैं ना?
Yes.
तो आप कौन सी jurisdiction को enlarge कर रहे हैं?
Appellate jurisdiction को enlarge.
यानी आप 185 में 184(3) की provision को ला रहे हैं?
तो हम ये कर रहे हैं कि because 185 में ये limitation नहीं है, because 185 में अगर ये हो कि for example 185 had said that in addition to what it says,
फिर देखिए फिर इसको देने की जरूरत ही नहीं थी. देखिए फिर तो आप किसी भी सुप्रीम कोर्ट की प्रोविजंस दी हुई हैं, तो आप किसी प्रोविजन को भी एनहांस, फिर तो आप हमें वो फिर तो देयर इज नथिंग लेफ्ट टू इट.
इसको इस तरह से अगर देखें, अगर सिंपल ये होता एक्सेप्ट द सुप्रीम कोर्ट एंड the entry had ended where it says authorized by or under the constitution, full stop, then you could not do anything.
नहीं, इसमें जरा मैं ऐड कर दूं कि ये जो अभी कर रहे हैं अपील, this is 184(3). So I raised this question earlier that if you provide an appeal in 184(3), it is not conferring a new jurisdiction, it's enlarging the jurisdiction of 184.
So that could be one way of looking at it, that you enlarge that jurisdiction and then you apply an appeal and there is no limitation under 185.
Where there is a specific article of the Constitution providing an appeal, and that specific article is intact, it doesn't provide an appeal, then you cannot provide an appeal in another article by under the garb of enlargement. Because appeal is a separate jurisdiction.
And so you read 184 and 185 together and see whether there is any limitation. Where there is a jurisdiction which exists and you extend
185 jurisdiction is not a jurisdiction in the form of an intra-court appeal. against an order of the Supreme Court. So there's a distinction. Now here there is already an existing jurisdiction under 184(3). That is simply being enlarged.
My lord, you read both of them together. I'll just, that's what I wanted. My lord, with this, I think one last question I have to address. Ladyship, you had a question about full
अगर आप conclude कर लें तो बेहतर होगा.
बस मैं वो full court वाली बात करके conclude. Yesterday, Mr. Faisal Siddiqui had made submissions.
ये इसमें Mr. Attorney General ये section 6 जो है right to appoint counsel of choice.
जी. जी.
इसका क्या मकसद है?
My lord, this is something which can easily be addressed. Now, of course, you have Order 26, Rule 6, where in exceptional circumstances you grant this power. As
नहीं यहाँ अगर आप right उसको दे देते हैं to appoint a counsel of his choice, तो इसका मतलब ये है कि कोई नया जो वकील आएगा वो full fledged argument करेगा तो जो spirit of review है जो कि अभी तक settled हुआ है by this court वो तो खत्म हो जाएगा.
This can be easily dealt with, as I was submitting, with the use. Now, my lord, with this provision,
वो तो
my lord
आपने
can.
Section 8 में लिख दिया हुआ है ना, it is to override any judgment of any court, including the Supreme Court or High Court.
उसको मैं explain भी कर देता हूँ, उसको ये भी explain कर देता हूँ कि now that we with the advent of technology, एक तो ये कि transcripts बन जाती है, but let's leave it that aside. With this provision in mind, my lords can suitably amend Order 26 to say require the counsels to file their written briefs, for example. In addition to the pleadings, they file their written
that
briefs.
That is already given
so that
in the Supreme Court rules, and that depends upon the court. If feel like.
So इसको अब regulate करने के लिए, further करने के लिए कि इसको कैसे effect देना है, उसका ये तरीका हो सकता है.
इसमें तो you have given it as a right.
जी मैं वही कह रहा हूँ कि ये right now this is a right at one end and there is a difficulty that you have just pointed out of the court at the other end. उसको balance किया जा सकता है.
अपील किया किसी और ने, रिव्यू दायर किया किसी और
ने, मैं उसी को explain तो कर रहा हूँ.
वो कोर्ट के सामने फिर शुरू से
मैं यही मैं कह रहा हूँ.
सेकंड अपील
मैं यही कह रहा हूँ कि then the court will go by the pleadings, वो written submissions हो सकती है. This is something which I appreciate the difficulty that you have pointed out.
Would that be a review stricto sensu or that would be second appeal?
No. I mean, if it is in review, obviously for determining the review or deciding the review, the principles of review that you have in Order 26 will apply. Now, the only difficulty that my lord has pointed out, there will be a different counsel arguing that case. I think in order to give effect to this section, Order 26,
fresh argument of the case.
वो उसमें my lord आप Order 26 Rule 6 में ये amendment कर दें कि जी beyond written pleadings, nothing new would be entertained, and that will take care of everything.
Learned Attorney General, even if another litigant exercises the right of engaging a new counsel, he would be still bound by the same principles laid down by this court.
Yes, and
so he can't go beyond that.
On judicial side,
when we allow a new counsel to come, he also stays within the limits of the jurisdiction.
He is bound by the pleadings which are before the court. And that would resolve that difficulty of a new person coming in, not being part of original proceedings. That might just resolve the difficulty.
Mr. Aji, it's Article 10 of the Constitution gives right to a person to appoint a counsel of his own choice. How can bar be put on a person that you should not appoint a counsel of your own choice? वो कहते हैं आज मुझे वकील पसंद मैं दूसरा रखता हूँ.
इसको फिर ये वही इसका जो बैलेंस है मानो वो बैलेंस ये हो सकता है कि आप अब जैसे कोर्ट रूम नंबर 1 I don't know if it is true or not, but there is a transcript of the proceeding.
There was some sense when this rule was made. There was some sense, but with this it will just expand the burden which is already on the shoulder of this court.
My lord, as I said, आप जो इसमें एक डिफिकल्टी जो मुझे आपके जो ऑब्जर्वेशन से नजर आ रही है वो ये है कि नया वकील आके कोई नई बात ना करे जो पहले नहीं हुई. यही डिफिकल्टी हो सकती है इन ऑल. सो उस पे इफ रूल 26 जो रूल 6 है ऑर्डर 26
पता कैसे चलेगा? देखें ना, वही वकील आता है तो उसको तो आप ये कह देते हैं कि भैया आप पहले आर्ग्यू कर चुके हैं, नया वकील आएगा उसको क्या पता पिछले वाले ने.
So have you bind them by the pleadings which are already on the record?
अगर मजे की बात ये है कि ये वाला प्रोविजन नहीं चैलेंज कर रहे हैं, वो कह रहे हैं ये ठीक है. वकील कह रहे हैं इधर तो हमारी फायदे वाली बात है।
Your Ladyship, if I may now address that question that you had asked. It's a question that you raised from the first hearing, and it has troubled many that what becomes of that right when there's a full court hearing.